Good evening. Good evening, everyone. Yes, very good evening. So, may I know where did I stop in the last class? I think we are supposed to be starting with judiciary. Is it right? My memory serves me good. I think we are about to start judiciary. Okay. All right. Tea only. Okay, Paul. Okay, let me ask you a few questions from what was taken in the previous class. Can a president withhold his assent to a money bill? President can withhold his assent to a money bill. Is the statement right or is it wrong? Okay. No, no, yes, yes, sir. Right. Okay. The correct answer is correct. He can withhold. Please be clear. Please be clear. As I told you, polity is a subject which is easy to learn and easy to forget. It's so simple. You just need to know the procedures, what is their competence. You just have to be aware of that. So easy to learn, easy to forget. So better keep revising, keep revisiting whatever has been taught. Okay. He can. Just that a president cannot send a money bill back for reconsideration. That alone is not possible. Apart from that, of course, a president can withhold his assent to a money bill also. Okay, all right. Can a president can withhold his assent to a constitutional amendment bill? Is it correct or is it wrong? Wrong. Correct. Okay. The correct answer is no. He cannot withhold his assent. Constitutional amendment bills, he is just supposed to give his assent. All right. Can you have a council of ministers when the Lok Sabha is dissolved? Can you have a council of ministers existing even if the Lok Sabha is dissolved? Is this condition possible? Yes, good. Okay. Yes, we can. Right. Can you name which amendment prevented a person, a legislator, who had been disqualified on grounds of defection? So such a legislator cannot become a minister until he recontests the election. Which was that amendment? Very good, very good, very fast and immediate response. 91st Constitutional Amendment Act. Good, good, good. See, I find a lot of people who are very sharp in this batch, okay, when it comes to answering. So I just want to know something about you. Can you just type what is your background? Because I've been told that we have so many students from college here. So I just want to know who is who. I mean, so that I don't get surprised to know that the ones who are giving correct answers are college students. So okay, right. Can you just type your name? I mean, your name is already visible. Just type your college. If you're in college, just type your college and which year in your college are you in. Okay. Or if you're full-time preparing also, so that at least something I can know about this batch. MBA. Okay. Was working with Goldman Sachs. Wonderful. Okay. So is this going to be a first attempt? Final year, fourth year, EC. Okay. Okay. So yeah, we have very sharp batch basically. We have this batch actually has a lot of people from some of the premier college institutions. So good preparing for UPSC. Right. Okay. All right. And it's a weekend batch which somehow I feel is a better batch all the time because weekend batch students, you are more focused and you have a proper routine of self preparation. The issue is with weekend batches, you have the entire weekdays where you prepare single mindedly, and only on the weekends you come and you actually get this is something like a gap filling exercise. Okay, when it comes to weekday batches, no, you have all different varieties of people, the ones who are not interested, the ones who have been pushed into preparation by their parents. So there's a lot of it's a very different group that we actually have in weekdays. It's a stark difference that I'm able to find between weekdays and weekend batches. So good. I really appreciate many of you from this weekend batch. You guys are performing really good. So keep it up. All the best. So we'll get into the class. And may I also know what is your scores that you're getting in the tests? What you're writing here? I'm sure many tests would have been already completed. May I just know a broad range of scores? What would be your average in your opinion that you're scoring in these tests here? Very good. 110 to 130, 60 to 70. Okay. 90 to 100, 50 to 60, 65. Okay. All right. So it's a good range of marks. So keep performing well. And my advice in the last few months would be focus on history and polity on a daily basis. Everything else will just fall in line. These two subjects just keep focusing. Okay. All right. We'll start with judiciary. As you are aware of, we have three organs of democracy, and judiciary is one among those organs. In any polity which is based on a democratic setup, you will have these three organs. Judiciary is there to check and balance the other two institutions. So this is essentially the concept of checks and balances, separation of powers, right? Okay. What does the constitution in India, what does it say about judiciary? Constitution says there shall be a Supreme Court for India. And the judges of the Supreme Court to appointed by the president. So this is what the constitution says. Okay. Don't you find there is a problem here? Judges to be appointed by the president, judges of the Supreme Court to be appointed by the president. Who is the president? President is the head of the executive. So don't you think there is a so this is like giving too much of powers in the hands of executive, right? When the president himself is going to appoint the judges, how would the judges act in an independent manner? They would be biased. They would be obligated to the president. So that is why um, ideal political setup would be where, what is this, 24. So ideal political setup is where executive is completely split from legislature is completely split from judiciary. Okay, this would be the best possible system where there is no concentration of powers, where there's a clear-cut separation of powers. Which model that you are aware of closely comes to this system? Can you think of any model? We have some broad models, right? So can you think of some models where, can I say, in the British model, we have this clear-cut separation of powers. Can I say that? No, it's in the US presidential system. That's correct. US presidential system, we have almost reached the system of near perfection. Okay, we have reached a set of near perfection. Why I say near perfection is we have a fair degree of separation between executive and legislature. And judiciary also we have received a fair degree of separation. In US, a judge, once he becomes a judge of the Supreme Court, cannot be removed. He will just continue to be in the judge until he himself retires. Okay, so you achieve a greater degree of separation of powers in the US setup, but in the UK, in the British model, you don't actually have such a great kind of separation. In fact, the system in UK is based on sovereignty of the parliament, parliamentary supremacy. That is the watchword of British parliamentary setup, right? So there, everything, so as I told you, the evolution has been in this direction. We went from a bad setup to a good, and it's becoming better and better day by day, right? So we started from monarchy, where everything was concentrated. From there, we went to the UK British parliamentary setup. So monarchy was in existence for like 5,000, 10,000 years. Whenever human beings started living as small groups of people, there was always a need for a leader who would do everything and anything to control the tribe, right? So that monarchy as an institution survived for a very considerable amount of time. UK parliamentary system, where the power was transferred from hereditary person to an elected group of person. That is the one great achievement, a jump from the bad days of monarchy, of authoritarianism, right? So we achieved something, some improvement, incremental improvement was achieved through this system. The next increment came in the form of US presidential system, where each organ is considered to be an effective check on each other. Okay, so that's the best system. You cannot achieve even further separation of powers. Okay, then you will have only chaos and you will not have any government happening. If you have the greatest amount of separation, even that also will become a problem, where each person would want to prove his supremacy. Okay, if there is no system of checks and balances at all, okay, if there is no, if all the three authorities are completely independent, think what can happen. Can you think what can happen if you have, see, here you have one ruler who is the supreme. Here you have a group of rulers. They are the parliamentarians. Here you go for three different kings, three different people who are supreme in their own ways. Congress, executive and judiciary. Okay. The minute you have a complete separation, nobody can touch upon anybody. Nobody can disturb another person. Legislature cannot remove their president. If you come to such a kind of a system, think what can actually happen. If you have such a kind of a very perfect separation, where one organ will not do anything on the other organ, all three are completely divorced from each other, do you think someone like Donald Trump, if he does something crazy in US, do you think whether can he be even removed? At least now he has, in US you have a system of impeachment. That is the way how legislature controls executive, right? But if you achieve complete divorce of each institutions, so there is a high possibility that one person will go completely amok. You'll not be able to do anything. So that's why you cannot achieve complete separation of powers, but to a fair degree US setup we have reached that, we have perfected it in US presidential system. So why I am talking about all these things is, in India, what is the setup that you find? As I told you, president appoints judges of Supreme Court. Okay, but the problem here is, if the president can interfere in the appointment of Supreme Court, how will the Supreme Court function independently? That is the question in our hand. Okay. And do you think the Constitution, do you think it tries to achieve this kind of a separation of powers? Do you think Constitution tries to achieve separation of powers and functions in any manner? Do you think so? As I told you, as of now, we still find the executive interference on the judiciary in terms of appointments. Do you think Constitution tries to prevent this interference? In some way, do you think the Constitution itself tries to promote greater separation of powers? Explicitly, Constitution has very good Article 50. That's very correct answer. Article 50 in the directive principles of state policy, you have an explicit provision. The state shall take steps to separate judiciary from the executive. Okay. What it means is, constitution makers have ensured a great degree of autonomy, great degree of independence for Supreme Court and High Court. But when it comes to lower levels, when it comes to district courts, you will not find the autonomy that a Supreme Court or a High Court judge enjoys, the same autonomy, the same functional independence, the same fearlessness district judges will not enjoy. That is why the Constitution keeps it as a directive principle. Please take steps to progressively, slowly bring judiciary at all levels completely independent of that of the executive or the legislature. So it's a visionary document. We have yet to find it implemented, but Constitution itself has so many provisions which ensures a great degree of autonomy for Supreme Court and High Court. And we'll see what are those provisions. Okay, how is the independence of judiciary ensured? We'll just have a look at this question in this today's lecture. Okay, so Constitution, it says President shall appoint the Supreme Court judges. Okay. Collegium system is not a part of Constitution. Constitution nowhere uses the word collegium. Constitution, it says Supreme Court judges shall be appointed by the President on consultation with the Chief Justice of India. Okay, look at the terminology that is used. Consultation. What is the meaning of this word consult? Give me your interpretation of this word. How would you interpret this word? Consult. CJI will be consulted by the President. How would you understand this word? Recommendations. Okay. Reaching him for advice. Good. So seems like a lot of interpretations, right? You can give a lot of interpretations. Advice, recommendations, opinion, taking tips. Okay, right. So there are just so many ways of how you can actually interpret this word consultation. And why do we have to care about this word consultation? Because it is this word which will completely change the power balance between the judiciary and the executive. How this word is interpreted depends on this one word, and its interpretation depends the entire independence of the judiciary. Okay. So why should we even bother about it? Initially, until Indira Gandhi's time, nobody bothered about this word consultation. Okay. So the system until then was, President will call CJI, President will ask him, who do you think I should be promoting as a judge of Supreme Court? Basically, the eligibility to become a judge of Supreme Court is citizen of India. He should have been a person who should have been a judge of a High Court for a period of 5 years. Okay, these are constitutional eligibility. To become a judge of Supreme Court, you should have been a judge of a High Court, or you could have been in multiple High Courts for a total period of 5 years. Meaning you should have spent at least 5 years as a judge of any High Court or many High Courts. Okay, and if you are not a judge of High Court, then at least you should have been a lawyer. You should have been an advocate in a High Court for a period of 10 years. These are the conditions. So there are just so many High Courts all across the different states, right? And President finds that there is a vacancy in Supreme Court judges. Right now, the total number of judges in Supreme Court is 33. Okay, and who decides the total number of judges of Supreme Court? Who has the power to decide what should be the total number of judges in Supreme Court? Do you know the answer? Do you know who is competent? Any answers? Do you know? The Constitution says, no, it's not the Bar Council. The Constitution says that Parliament will create a law. Parliament law will specify what should be the number of judges. And Parliament has actually created a law. I don't remember the names. Supreme Court Judges Act or something. Okay, I don't remember the exact name of the law, but a law is there in place. That law will be periodically amended. That act will be periodically amended so that the number of judges can be increased as the caseload also increases. So as of now, the amended act as it stands today, the total number of judges in Supreme Court is 33. Okay. So we have a 33 judges in Supreme Court. Sorry, 33 judges plus 1 CJI, 34 judges. So CJI plus 33 other judges. So let's say there are 3 vacancies. So the judges are about to retire. Okay. In that case, who should be elevated? Who should be brought? You have Madras High Court, and you have a judge who has been a judge for 10 years. You have a Calcutta High Court. You have a Cuttack High Court, from where you can actually elevate judges of High Court as judgeships of as the judges of Supreme Court. Okay, so for this elevation, until Indira Gandhi's time, until 1970s, Constitution came into force from 1950. 1950 to 1970, there was no problem. There was no problem of interference of executive in judicial appointments. So what the president was doing is, president will give a call to the CJI. He'll ask, there are 3 deserving candidates from 3 different high courts, and I would like to elevate one of them as a judge of Supreme Court. So who do you think I should be elevating? And the CJI will give his opinion. Please elevate the judge of Madras High Court. He's a long-term associate of mine. I know what kind of a judge he is. He's a man of great caliber. So please bring him up to Supreme Court. His services are much required in Supreme Court. And immediately the president will make an order. Okay, the judge is elevated and he's made as a judge of Supreme Court. This was how system was going on until Indira Gandhi's period. And at the end of this lecture on judiciary, we will also be discussing about a doctrine called as a basic structure doctrine. Okay, that basic structure doctrine relates to amendability of Indian Constitution. At that time, you will come across a lot of conflicts. Conflicts means it's about whether Parliament can amend Constitution or not. That is the essential question. And if it can amend, what should be its limits? Can it just amend anything and everything in the Constitution, or there should be some kind of provisions which would not be amendable by the Parliament, which are so essential and so basic and foundational that even Parliament should not be allowed to tamper with those provisions? Do we have any such provisions in the Constitution? So these questions were actually resolved through a series of cases, starting from Shankari Prasad's case. You would have heard about Golaknath's case. You would have heard about Keshwananda Bharati judgment, Minerva Mills judgment. So there are some case laws. So these are all cases, litigations in the Supreme Court. So Supreme Court judges gave their opinions, whether Parliament is competent enough to amend many parts of this Constitution or not. Supreme Court gave its opinion in various different cases, judgments. Okay. So, and at times, these judgments went against the government. The Supreme Court has to do its own job. It has to look into the law and it has to examine the law and its merits and demerits, and it has to come up with a judgment. And of course, the judgment will go against the government also. Okay. So, what Indira Gandhi did was, she was not able to digest that there are people who are going against me. How can the judges who are not elected by the people popularly, how can they nullify what a popularly elected government does? She was angry with the judges. Okay. So that is why she decided, okay, the problem is because there are so many judges in Supreme Court who do not share the same political attitude as the Indian National Congress. So what I'll do is, I'll only elevate judges who have similar political inclinations. So that was when the interference of executive into judicial appointments started. Okay. So in 1973, when Keshwananda Bharati judgment was delivered, at that time, the total strength of Supreme Court was 13. 13 was the maximum strength then in 1973. Today in 2021, it is 34. So slowly the number of judges has kept on increasing. So all these 13 judges sat together in the same case, Keshwananda Bharati's case, all 13 judges. It's a full bench judgment. Okay, full bench judgment where all the judges had to sit together. They had to apply their minds and they had to come up with a judgment. Okay, and the verdict was 7-6. 7 against the government, 6 for the government. That is, this entire Keshwananda Bharati issue is about whether Parliament can amend a constitution or not. Okay. So 7 of them, they said that Parliament cannot amend all parts of the constitution. There are certain parts which can be amended. Whereas 6 judges, they said that Parliament can amend anything and everything in the constitution. That was exactly what the government wanted. Because the government, having its complete majority in the parliament, it just wants to use its majoritarian power by bringing in drastic amendments to the constitution, which is affecting the fundamental rights of a lot of citizens. That is why these cases were even litigated in the Supreme Court in the first place. So these seven judges who gave a verdict which was not acceptable by the government. If you see who are those seven judges, you will find Chief Justice of India. He was one among those seven judges. And after CJI, you have the seniority of judges. Okay, the date in which they had come and occupied their position as a judge of a Supreme Court. From then on, that will be the calculation of seniority, basis of calculation of seniority. So you have the Chief Justice of India, then you have the senior most judge, the second most senior most judge, the third senior most judge. All of them were on this side, whereas the fourth senior most judge, he was on this side. Okay, so other judges, maybe 5th, 6th, 7th, 8th, 9th. Let's not worry about other judges. So this was the situation. CJI and 3 other senior most judges, they were on this side. They gave against the government. Whereas the 4th senior most judge and other judges, and another 5 more judges, they were on this side. So this guy's name, 4th senior most judge, his name was A.N. Ray. Okay. He gave a verdict which is favorable to the government. But this is a split verdict, right? 7:1. Sorry, 7:6. So majority verdict is on this side. So the entire judgment went against the interest of the government. That is a different story. But you have to see this. So after Keshavananda Bharati case is over, within 6 months or something, the Chief Justice of India, he is about to retire. Okay. Usually the system in the Supreme Court is, after the CJI retires, the next senior most judge, he will be immediately made as the Chief Justice of India. This is the usual practice in Supreme Court. Executive will not interfere in this. Okay, so this is some kind of a consensus or some kind of a practice which the Supreme Court itself had evolved, so as to avoid conflicts within themselves, so as to avoid rat race among themselves, so as to avoid satisfying the executive. Okay, so this is some kind of a principle which the Supreme Court itself had evolved. On the base on the retirement of the CJI, the next senior most judge will become the CJI. President will just make his appointment as a CJI of India. Okay, this was how it was supposed to happen until 1973. This process was not broken; it was just followed. But after Keshavananda Bharati judgment, you know what happened? President, he bypassed all these 3 senior most judges. This guy was brought as the CJI of India. These 3 judges were bypassed. So now these 3 people felt ashamed. He is my junior and he is now becoming my boss. I cannot accept it. So these 3 people, they resigned from their judgeship of Supreme Court. This was a starting point of conflict between executive and judiciary, executive interfering into the affairs of judiciary. Okay. So these kind of tendencies went on, and even in 1970s, there was a time of emergency also. Even during emergency, this kind of a bypassal of senior most judges actually took place. Even during emergency, the Supreme Court acted as the guardian of fundamental rights of people. Wherever fundamental rights was violated by the government, Supreme Court came to the rescue. Supreme Court used its writ powers and quashed the actions of the government. Many people were released. So again, there was a conflict between the government and the executive and the judiciary. So even in the independence, post-independence period also, this same kind of a phenomenon was once again repeated. Okay, so all these were a clear indication of how executive can start interfering and arm twisting the judges of Supreme Court. Okay, by showing that the final call is with the executive on who should become the CJI of India, who should become a judge of Supreme Court. The final call is something that the executive shall take. That kind of a message is definitely going to create a culture of subservience in the minds of the judges of Supreme Court, right? So that is why this tendency was just going on. And finally, in 1982, there was a case. Okay, there was a case which was actually fought in Supreme Court. The name of the case is S.P. Gupta versus Union of India. In 1982, it is this case which is called as the first judge's case. First judge's case. The case is regarding judges. That's why it's called as the first judge's case. But the real name of the case is S.P. Gupta versus Union of India. What is the substance of this case? S.P. Gupta was a lawyer. So he had filed this case so as to protect the judiciary from the interference of executive. So the question that was put forward before the Supreme Court judges in this case was, what is the meaning of this word consult? When President consults with the Supreme Court judge, Chief Justice of India, what is the meaning of this word? How to interpret this word consult? Okay. And the Supreme Court, at this point of time in 1982, it was not very assertive. Okay. It just felt that maybe Indira Gandhi is an exception. Indira Gandhi is creating this interference. Jawaharlal Nehru never created any kind of interference. So maybe the next successor will also not create any kind of a interference. So let's hope for the best. And Supreme Court during this time, its opinion was that the word consult means exchange of views. Okay, so what does it mean? So if it's just an exchange of views, do you think it's such views will be mandatory or binding on the president? The Supreme Court said that in the first judge's case, it's merely a formality of exchange of views, and the views are not binding on the president. The president is not just bound to follow whatever the CJI says. It is the president who will have the final say in this matter. So we should not actually unnecessarily interfere in the president's power of appointment of judges. So they expected that the future presidents will not be influenced or will not interfere. They would exercise their good faith and wisdom in exercising their powers of appointment of Supreme Court judges. Okay. This was the verdict in first judge's case. Exchange of views, and it is not binding on the president. So then the same kind of problem continued even under Rajiv Gandhi also. So finally in 1993, the second judge's case was fought. Okay, second judge's case. And let me tell you, Constitution says what does it mean? Any question on how to interpret the Constitution has to be heard by at least a minimum of 5 judges. So this 5 judges what is called as a constitutional bench. Constitution, how should I interpret? What should be the meaning of the word consult? Adha vandu interpret pandradhukku you have to have a minimum of 5 judges to do that. Okay, this is what is called as a constitutional bench. Any question on interpretation of the Constitution needs 5 judges. Okay. So let's say in S.P. Gupta's case, let's say I don't know the exact number of judges. Let's say in S.P. Gupta's case there were 5 judges. They will not unnecessarily constitute 7 judges bench. Minimum 5 judges is required. So let's constitute 5 judges bench. I may be wrong about the number, but what I'm trying to say is the Supreme Court has given a verdict in S.P. Gupta's case that consultation means exchange of views. And this problem was just going on, and finally in 93 the second case was fought, which is called as Advocate on Record Association versus Union of India. Okay. Someone please check the date. Is it 92 or 93? I think it's 93. Maybe you will find it in Lakshmikant, whether it's 92 or 93. Okay. So this case is what is called as a second judge's case. What is this? Advocate on Record Association. In Supreme Court, just like your college, in your college, all your professors, all of them are highly educated, but you have a category of professors, right? You have professor, associate professor, lecturers, assistant professors, you have ranking. Similarly, among the lawyers of Supreme Court, okay, among the lawyers of Supreme Court, you have a kind of a hierarchy, a ranking. Okay, the senior most judges are called as senior judges. Sorry, not the judges, advocates. They're called as senior advocates of Supreme Court. Next in line comes advocate on record. Then you have the other judges. Okay, anybody who has qualified for bar exam can get himself registered as a judge. As an advocate in Supreme Court. Each court will have its own bar council. Okay, each court will have its own bar council. That is, it's like a group of lawyers. Whoever is registered as a member of that particular bar council, so they can actually practice before this court. So among these members, you have this kind of hierarchy. Some advocates are very senior. Some advocates are quite senior. Some are just new entrants, fresh out of college. They would want to involve in legal practice. So they will be assistants to other judges. So you have these kind of hierarchy, and it's these lawyers, advocate on record, they have their own association. Okay, they will have their own disputes among three categories. So they have their own association called as Advocate on Record Association. So this association had filed a case in Supreme Court regarding a need to once again re-examine the meaning of the word consult. Okay, so another constitutional interpretation was required. And let me tell you, the convention in Supreme Court is a 5-judge bench in S.P. Gupta's case. They had given a verdict. They have given their opinion on how to interpret the word consult, right? If Supreme Court has to do away with its earlier interpretation, if Supreme Court wants to give a completely diametric interpretation, always keep this in mind, this can be done only by a bench comprising of more number of judges. That is why in second judge's case, I think the number of judges in second judge's case was around 7 judges or something. Okay, definitely higher than the S.P. Gupta's case, because in this case it involved reinterpretation. So what if the Supreme Court gives a completely opposite opinion of what the Supreme Court had earlier given in S.P. Gupta's case? So you require more number of judges, and this is exactly what happened in Advocate on Record Association. A higher bench, a higher judge bench, they overturned the interpretation as done by the S.P. Gupta bench. Okay, what did they overturn? They said that the meaning of the word consult in second judge's case, the meaning of the word consult, it means concurrence. It is not limited to merely exchanging my views. No, it means concurrence. So what is your understanding of this word concurrence? What do you understand by this word concurrence? Yes, a simple understanding. Okay, you have taken it forward by saying that it is binding. Result or final should go hand in hand, of course. So what did concur, to be in agreement with, to agree with, don't you think so? Agreement would be a better definition. Yes, to concur means to agree with, right? So this is the verdict. So it means that they are overturning the judge earlier decision that it is not binding on the president. Here they are saying that it is binding. What the judges should be in agreement with the appointee. The judges should actually accept the appointee. Sorry, not the judges. The CJI should be okay with the appointee. Okay, that is what is called as concurrence. So CJI should concur. Only then the president can make an appointment. Not only this, it was in this case for the first time a system called as a collegium system was put forward. The judges in second judge's case, they gave this opinion saying that consultation with the CJI does not mean the CJI's sole opinion. It's not his own individual opinion. CJI's opinion means opinion of 2 other senior most judges of Supreme Court. Okay, it means what do I say? Many other judges should also be. It's not a sole. It's not the sole thought of CJI. He has to first discuss with other judges. So other judges means how many judges? Second judge's case, it stated down clearly that a collegium concept has been brought in. A collegium means a multiple member body. So CJI alone is not the person to be consulted. CJI has to consult with two other senior most judges also. So in accordance with that discussion that he has with the other senior most judges, a name should be recommended to the president. Okay, this is the outcome of second judge's case. All right. So with this, the problem stopped. Okay. So after that, there was no interference of executive into judicial appointments. But you also had a third judge's case. This third judge's case it is not a litigation between two parties. In first judge's case and second judge's case, it is a litigation between two parties. Who are the parties? First judge's case, it is SP Gupta is one party, government is another party. Second judge's case, advocate on record is one party, government is another party. Third judge's case is not such kind of a dispute. Third judge's case is slightly different. Third judge's case is what is called as it's a presidential reference that has been made under Article 143 of the Constitution. Okay, I'll explain to you this first, then we'll proceed further. What is this presidential reference under Article 143? See, President is a layman. President has no idea about law. He has no idea about what is basic structure. He does not even know probably how to clearly understand the legal language. And if he is such a person, how can he look into the merits and demerits of a bill that is passed in parliament? Do you think a president is capable of doing that? A complex law which is made in the parliament, whether it is in tune with the constitutional principles or not, whether it is violating the secular principles or not, do you think the president is capable enough to differentiate that and to arrive at a conclusion? Do you think a president can do that on his own? No, he cannot. That is why president has an advisor in the form of Supreme Court. Constitution keeps this as one of the powers of Supreme Court. No other court has this power of advising the president. Okay, only Supreme Court has this power of advisory jurisdiction over president. That is, whenever president has a legal question, if he refers it to the Supreme Court can give an advice for that particular question. Okay, please show Article 143 slide. Can I move forward? Okay. So, there is a power given in the Constitution. What is that? President, whenever he has a legal question to be answered, so he is not able to understand the bill, so he will make a reference to the Supreme Court. He will refer the matter to Supreme Court. The Supreme Court will give an answer to the president on whether citizenship amendment bill passed by both houses of the parliament, is it in tune with the principles of the Constitution or not? Supreme Court will apply their mind, judges will apply their mind, and they will give an opinion. Okay, so this is the power of Supreme Court under Article 143. So I'll explain to you in detail. Okay, once we discuss about different jurisdictions of Supreme Court, I'll explain to you there is something more to be discussed. As of now, what you need to know is Article 143 gives this power to President. He can make a reference to Supreme Court to get its opinion. So Supreme Court, so President, I think in 97, okay, President is not still clear about how to go about this collegium system. Supreme Court had vaguely, they have defined a concept called as collegium, but I don't like the members of collegium system. So what should I do now? If you give a, sorry, not members, collegium has given a recommendation of judges, which I don't really like as a president. I find there are so many criminal cases against some of the judges. So does it mean that I should just be blind to whatever advice has been given and I should just blindly accept the advice and make a order? No, it should not be the case. So please give me more clarification on how to proceed with this judicial appointments. So that was the presidential reference that was made to Supreme Court under Article 143. So this is what is called as the third judge's case. Okay, even whenever president makes these kind of references, even these references, the judges will not just sit in private five judge bench. They will not sit and they will think and they will arrive at an answer. No, it has to be discussed in an open court. There will be lawyers arguing both pros and cons. Okay, the counter arguments will be given, arguments will be given for a particular viewpoint. So this is how even presidential reference under Article 143 an answer is arrived at. So in open court, all these discussions and everything happen. And finally, this is what is called as a third judge's case. And in this third judge's case, Supreme Court, it gives a set of guidelines to be followed. What are they? Supreme Court gives some clarity on how should this judicial appointments be done. Okay. So what are the series of guidelines? Supreme Court says in third judge's case, collegium means CJI plus 4 senior most judges of Supreme Court. It is not the individual opinion of CJI, it is the opinion of this collective body called as collegium. CJI has to get these judges' opinion on this matter. Okay. What opinion? There is one vacancy in Supreme Court and there are 3 judges who are contesting. Who are contesting in the sense 3 judges are eligible. There is one judge from Madras High Court, one judge from Calcutta High Court, one judge from Bombay High Court. So 3 judges are eligible now to be elevated. Okay. So what is the guidelines that has been given by Supreme Court in the judges case? One is it clearly lays out what is the collegium that is required for Supreme Court judges, for appointment of judges to Supreme Court. Next is, out of these 4 senior most judges, let's say all 4 senior most judges, they are unanimously saying this person is the most qualified person. Okay, so his judgments speak for him. The quality of judgment is something which is very fair and just to the victims. So hence, I feel among the 3 judges, he is the most qualified and he is an alumni of National Law University. So he is the most deserving. Okay. But CJI, he is not okay with the judge's choice. If that is the case, CJI has the power of veto. Even if all 4 judges support a person, it doesn't mean that just because they are in majority, CJI can be bypassed. No. CJI has the final call. Even if all of them support a judge, still CJI has the power of veto over their opinion. This is the second point that you have to remember. CJI's veto. What is the third? Any decision of the collegium has to be a majority decision. That is, it should always have CJI on board. CJI plus 2 judges. Yes, you get a majority, 3 out of 5 judges of collegium, right? As I told you, if CJI is not on board and if 3 judges among the senior most judges, if they give their opinion, even in that case, CJI can exercise his power of veto. That is why I say CJI should always be on board with respect to a particular recommendation, and at least you should have the support of 2 other judges. So the collegium recommendation is based on majority, but ultimately CJI has to be on board. He has to be a part of that recommendation. He cannot be against the recommendation, okay, because he wields the power of veto in his hands. All right. So this is the system, okay. The next guideline that was put forward in the third judge's case was, let's say the collegium, it makes a recommendation. Collegium says Bombay High Court judge, he is the one we find fitting and deserving to be elevated as a Supreme Court judge. Now what the president does is, president will send this CBI. CBI is under the, whenever I say president, I mean the appointed council of ministers. I mean the executive. Okay. When I say president, just because president is the head of the executive, I'm just referring to him. But otherwise, the executive in the real world sense would actually mean the council of ministers who are popularly elected. So the CBI is under the control of the government. CBI will be asked to go and probe his background, whether the judge is a man of integrity or not, or is he someone who is a very corrupt person. Because these judges of collegium, they will only look into the quality of the judgment. They will not know about what kind of a man he is. Okay, so maybe he could have actually earned a lot of bribes. So that's why the government will do its own inquiry about the antecedents of the judge, whether he is well known for his integrity or not. All that will be verified. And let's say CBI gives a report, no, this judge has a disproportionate asset of 500 crores, but his salary per month is only 2 lakh rupees. How could he have earned 500 crores? So something is not correct. He is a corrupt person. Okay, maybe he is not having it in his own name, but his relatives are having such kind of an assets, which is very suspicious and which is doubtful. So there should be a better person who should be brought to Supreme Court. Okay, if president is not satisfied with the recommendation, what can the president do? That is what I'm trying to say. All the CBI and all the story, I'm just bringing to your perspective to tell you that president is not satisfied with the recommendation that is being made by the collegium. Okay, the judge is known for his misbehavior with female judges and advocates. Let's say he is widely infamous for his unprofessional conduct with women members. Such a kind of a person, why should he be brought to Supreme Court as a judge when there are better people in the form of Madras High Court judge? He may be a really better person. So president, he is not okay with the recommendation that is being made. So what will happen? President will communicate this to the collegium. Whatever problem the president has, he will communicate to the collegium in the form of writing. He will clearly put it down in writing and say, this is the reason why I do not want this particular judge to be brought as a judge of Supreme Court. Now, what will the collegium do? Collegium will look into the reasons, whether the reasons are valid reasons or not. Or is the president just avoiding that judge because when our present home, let's say there is a judge from Gujarat High Court. A judge from Gujarat High Court is also in the list. And instead of Bombay, let's say it's Gujarat High Court judge. Okay. And let's say this Gujarat High Court judge, when he was a district judge in a particular district, he had given a verdict, he had given a judgment against Amit Shah. Amit Shah was at that time a petty businessman in Gujarat. So he had given a judgment against Amit Shah, because of which Amit Shah had to spend 2 years in jail. Okay, hypothetically, this has happened. That is why maybe intentionally the president is cooking up all these stories and he's trying to prevent this elevation of this judge to Supreme Court. If the collegium will look into the reasons. Whatever is communicated by the president, the collegium will look into it. And if it finds that the grounds are flimsy, it's not really valid objections which the president has actually raised, in that case, the collegium will once again reiterate. Okay, if the grounds are not valid grounds, if it's just for the purpose of avoiding this judge, the government is intentionally giving such kind of excuses, collegium will reiterate the recommendation to the president, and president must appoint the name of the judge who has been recommended. Okay, this is how the judiciary, through 3 judges' cases, had finally come with a system which makes the judiciary independent of the executive, which prevents the interference of the executive into the appointments of judicial members, judges, right? So this is how the independence of judiciary had to be hard fought by the judges themselves, so as to have a sense of independence from the executive. All right. So this is all about the first controversy with respect to judiciary, with respect to appointment of judges, and to what extent can the executive interfere in when it comes to appointment of judges. Right. Okay. Any doubts? Are you clear? Do you have any doubts? Were you able to follow whatever was discussed? Sir, after second judge's case, also there is a possibility of interference. How? How is that possible? How? Why do you say there is a possibility of interference after second judge's case? Okay, now it's clear. All right, all right. Okay, so this is with respect to appointment of judges. But the constitution has so many other provisions through which the independence of judiciary is ensured. Okay, what are the constitutional provisions? Why CJI has veto? Is it to respect the constitutional provision? See, otherwise what will happen? The constitution says the president should consult with CJI. Supreme Court's invention is that CJI, it is not his own sole opinion, but it has to be an informed opinion that is arrived at after interacting with four senior most judges. Why is this provision kept? So that CJI does not favor anybody. Correct? This provision is kept so as to make sure CJI does not favor anybody. The constitution makers have never kept CJI alone can also recommend a name. That is not, sorry, the Supreme Court judges, they did not say that CJI can overturn the other judges and he can send his own recommendation. If that is the case, then this collegium system itself is not necessary. But at the same time, just by using a majority, the other judges should not be able to prevail over CJI. They should not be in a position to prevail over CJI himself. Okay, so CJI will be having a power to say no, but he himself on his own cannot say yes. I hope you understand what I'm trying to say. Okay. Can the government change collegium powers through law passed by parliament and assent by the president? It's not a power. It is not a power. It is a system which Supreme Court has evolved so as to clearly define the word consultation. And the consultation means what process has to be involved. It's a set of processes that has to be performed. When you say judge of CJI has been consulted, when you say that yes, I had consulted the CJI, it means that all these set of steps should be performed. So it is not a law or anything. But if the parliament makes any law bringing in some other provision, okay, bringing in some other method, let's say the parliament in 2014, they came up with a constitutional amendment for the creation of a body called as National Judicial Appointments Commission. What is the purpose of that body? The purpose is just like UPSC, Union Public Service Commission. What is the purpose of UPSC? It is to recommend names, conducts an exam, selects candidates, recommends the name to the government. Then the government will decide whether the recommendation should be accepted or not, whether these people should be appointed as IAS, IPS officers or not. UPSC is a recommendatory body. Similarly, constitutional amendment was done so as to create a body called as National Judicial Appointments Commission. I don't remember the number of that Constitutional Amendment Act. I think it is 99th Constitutional Amendment Act. Not very sure. An Amendment Act was brought so as to bring in this body called as National Judicial Appointments Commission. Okay, so this means that the collegium system is now bypassed. You are creating a new provision, right? So what happened to that National Judicial Appointment Commission? That provision was struck down as unconstitutional. Supreme Court said it is violating the principle of separation of powers. It is violating the independence of judiciary. So it goes against the basic principle of the Constitution itself. That is where the basic structure doctrine comes into picture. Okay, I'll have to teach you that basic structure doctrine, only then you'll be able to make sense of that. So National Judicial Appointments Commission goes against the principle of separation of independence of judiciary. Independence of judiciary is one of the features of basic structure doctrine. Hence, NJAC Appointments Commission was declared unconstitutional. So any other method that tries to replace this collegium process will be evaluated by the judiciary if it actually can violate the independence of judiciary or not. So it will be struck down as unconstitutional if it violates the independence. So CJI can stop but cannot force his recommendation. That is correct. Yes, that is what I was trying to say. He can prevent others from dominating, but he himself cannot dominate over others. Okay, one man cannot dominate over everybody else, but just because there is a majority, the majority cannot dominate over CJI. That is the safeguard that has actually been introduced. Okay. So what are the other ways how the Constitution ensures the independence of judges? As I told you, first, an independent collegium. So this is already discussed. Next, what would be the best way to make judiciary financially independent? Why is Election Commission of India criticized? Why is ECI criticized as not so independent body? Election Commission has to go and beg from the government each time. Even to hold elections, Election Commission does not have its own money. It has to first ask money from government. Please give me money. I have to pay to all election officers on duty. I have to conduct elections. I have to put diesel for election commissioner's vehicle. Okay, it has to go and stand before the government. That is the reason why Election Commission is not able to function in an independent manner. So how can you ensure the independence of judiciary? By making sure salaries of judges, their pensions, and not just this, the entire expenditure of Supreme Court and its staffs. All these are charged on the consolidated fund of India. Do you understand why? So what is the other kind of expenditure? One is charged expenditure, the other one is voted expenditure. Charged and voted. Who votes on the expenditures? It is the legislature which will vote on the expenditure. Imagine what can happen if the legislature can discuss, can somebody tell me what would be the consequence of legislature voting on the salaries and pensions of the judges? Can somebody just think and tell me? Why charged and why not voted expenditure? Because if it is going to be a voted expenditure, the judge's salary can also be reduced. Yes. What is the need? Do you remember the process called as voting on demand for grants? I had discussed it very earlier. Voting on demand for grants. Do you still remember this word called as voting on demand for grants? Yes. What all can happen to the demand during the process of voting? And what if I ask you a question? Both houses of parliament will vote on demand for grants. Is it right or is it wrong? Right? Very good. It's wrong. Only Lok Sabha has the power to vote on demand for grants. Right? Very good. Very good. So, let's say if the judge's salary, their pensions, their expenditures are going to be voted. And during voting, have you heard of cut motions? Yes, very good. Very wonderful. Cut motions. That's the answer that I was expecting. The purpose of voting in Lok Sabha is to introduce cut motions. Cut motions are introduced so as to reduce the demand, so as to completely abolish the demand. So can I say that the salary of judges can be reduced? Cut motions will be passed and salary of judges will be discussed. Why give 3 lakh to that old guy? Let him get only 1.5 lakhs. Already country is facing corona crisis. So we will give him only 1.5 lakhs. And such a voting happens. It's not good for the country. If that is the case, then A judge of Supreme Court will not be fearless to strike down a law made by the legislature as null and void. Supreme Court judge will think twice before declaring a law as unconstitutional. Supreme Court judge will be scared of the parliament. That is why his salary, expenditures, pensions, nothing should be left to the vote of parliament. It should be just be charged on the consolidated fund of India. Okay. So this is the purpose. This is the purpose that we are achieving. We are granting independence. A bill for charging an expenditure on the consolidated fund of India will be certified as a money bill by the speaker. Is it correct or is it wrong? A bill for creating a new charged expenditure, it will be certified as a money bill by the speaker. Is it right or is it wrong? Yes or no? Right. Correct. The answer is good. Correct. Article 110 gives a lot of criteria which can make a bill to be certified as a money bill by the speaker. Okay. A bill that deals with expenditure is called as a financial bill. Is it right or is it wrong? Any bill that deals with expenditure is called as a financial bill. Is it right or is it wrong? Okay, good, correct. Right. Good. So this is another method of how the Constitution ensures judicial independence. What else? What other mechanisms do we have in place so as to ensure independence? Next is independent collegium part of the constitutional provision? No, it is not a part of the constitutional provision. No. Maybe I would have mistakenly I would have written it as the first point, but that is not given in the Constitution. That is a judicial invention. Ban on practice after retirement. So tell me, why is this necessary? Why do you think there has to be a ban on further judicial practice after his retirement? He cannot, a judge of a Supreme Court, once he steps down, he retires, his maximum age is up to 65 years. He cannot be in office after 65 years. After 65, he cannot practice as a lawyer in any other court in India. Can somebody tell me why? Why would this provision be kept here? As Attorney General after retirement, he can be posted as an Attorney General. Constitution only says he is banned from legal practice. He can be made as a part of, he can be given any other public offices. There is no problem about it. Yeah, post-retirement jobs can be offered. He can be made as members of commission. He can be made as a Lokpal. He can be made as a chairman of National Human Rights Commission. There are so many avenues to which a judge of the Supreme Court can become. He can even be given a Rajya Sabha membership also. See, they favor government judgments while in office, thinking that he might get any job. No. That is what I'm saying. The purpose is not, this provision is not kept in the Constitution to shield a judge from the government. That is not the purpose. Tell me, what is this purpose? Just think. He is not getting any office. Okay, he is only he is prevented from practicing law. Why is that? Why is that the case? They favor government. Okay, he give biased judgments to get case after retirement. Okay, that is the correct answer. Okay. What can happen is, you see, he is the one who, let's say a judge of Supreme Court, he is the member of this 4-judge collegium. He is one among the senior most judges, CJI plus 4 collegium. During his tenure, Bombay High Court, Calcutta High Court, let's say some 6 vacancies from the high courts were all filled during his tenure. Okay. Now, after retirement, he comes as a lawyer and he is going to practice before one of the judge. His own relative or his own favorite friend may be brought as a judge to Supreme Court, and this one among the senior most judges, he is now going to appear before this judge. Do you think there will be any justice in that case? Probably he will be hired by Reliance to appear on their behalf in front of this judge, and these judges are close buddies to each other. That is why there is a chance of no fair a judgment being given if this judge were to be allowed to practice. That is the reason. Not only here, even in high courts also. When we discuss about high court, you will come to know about the collegium system that is followed for high court judges appointment. How are the judges to high court appointed? Even there, the senior most judges of Supreme Court, they have a role to play. Okay, so we will discuss that. So that is why even district judges, they will be made as the judges of high court by a collegium. So such kind of judges, their favorites will be elevated to high courts, and this judge after retirement, if he goes and practice pleads before that particular judge, there will not be any fair judgment that will be the result of such a process. That is why, to prevent this problem, there is a ban on further legal practice post retirement of a Supreme Court judge. Okay, so this is one method that we follow, that the Constitution has, so as to secure the independence of the judiciary. What else? We also have another safeguard in the form of a very, very tough removal process. A judge of Supreme Court cannot be removed so easily. A very difficult method has to be adopted so as to unseat him from his post of a judge of Supreme Court. Okay, so that it does not become easy for the parliament to remove a judge. It's very tough. That is how we ensure the independence. What is that difficult process? We will just take a short break and we will discuss after the break. Okay, we will take a 10 minutes break and we will discuss. Is there any ban on government jobs after retirement? There is no ban on government jobs. He can, that's what I said. See, government job. What do you mean by government job? He cannot become a secretary of the government of India, because he is not an IAS officer. It's only when you enter into service and you have put in 30 years of your service as a public servant, as a member of executive, you become eligible to become a secretary of the government of India. So he cannot be posted as a secretary or to any other public offices in various ministries. No, nothing. He cannot be given such posts. He can only be made as member or chairperson of various commissions and other constitutional and non-constitutional bodies. He can be made as a member or chairpersons. Okay. Like nominated member in Lok Sabha or Rajya Sabha, that is his democratic right. A judge, his right to contest elections is his democratic right. So there is no bar on that. So that is not that will not come under the definition of a public office. No. Okay, what is this removal process? We will discuss after a short break. Okay, 10-minute break, and we will continue our discussion after that. Or is it okay if I continue the session? Will it be okay if I continue the session and I conclude it by 8 o'clock, 8:15, instead of finishing it by 8:30? What would be your opinion? Do you need a break right now? Yes, I think that will be better. We'll continue straight and okay, no problem. Then fine, I'll just continue. So what does the Constitution say with respect to the removal process of a judge of a Supreme Court? The Constitution says that judge of a Supreme Court shall be removed by the President. But he will be removed by the President after a motion for his removal is passed in both houses of Parliament. And this removal motion has to be passed by a special majority. This is what the Constitution says. Okay. But the Constitution does not talk about any further procedures or minute procedural aspects, just like how we have a rules of procedure of Lok Sabha to talk about minute nitty-gritties of the daily procedures to be followed in Lok Sabha. Similarly, the Constitution does not actually talk in detail about this removal process. It is left to Parliament to create. Parliament has made a law which is called as so Parliament by law has created a procedure. It has come up with a procedure that governs the removal process of a judge of Supreme Court and a High Court. How should a judge of Supreme Court and a High Court be removed? Is governed as per the procedure given in Judges Enquiry Act. Okay. So what is the procedure? So I told you a removal motion has to be first passed in both houses of Parliament. So do you remember what is a motion? Do you guys remember what is a motion? We have discussed during Parliament discussions. Is it still intact in your mind? There are 3 different phases for the passing of a motion. Did I tell you that? The motion has 3 phases to it. Are you turning back your pages and seeing what has been discussed? What is the purpose of motion? As soon as I tell you motion is introduced in Parliament, what would be its purpose? Tell me. Very good. Yeah, that's correct. Admission, discussion, and adoption. Somebody has said approval, adoption, and voting. Right. Introduction, discussion, and approval. So I use a different word. ADA. Admission, discussion, adoption. Okay. But what is the purpose of a motion? The purpose of a motion is to take leave of the House. Why to take leave of the House? So as to discuss about the conduct of a judge of a Supreme Court or a High Court. And again, if I have forgotten to mention about this, this is another safeguard to protect the independence of the judges. There shall be no conduct, there shall not be any discussion on the conduct of a judge of a Supreme Court or a High Court without his removal motion being introduced in the Parliament. What it means is, Parliament as a body, it is for the purpose of discussions. It is for the purpose of debates, deliberations on a lot of national issues. Okay, now there cannot be anything that should not be discussed in Parliament. But yes, there are some things which cannot even be discussed in Parliament, and one such thing is the conduct of judges of Supreme Court or High Court. Why is this safeguard there? Let's say there is a bill which is passed in the Parliament. Okay. Or let's say there is a particular section of IPC, Indian Penal Code. It has a provision. It has I think 497 or something. It has a particular provision in IPC which makes homosexuality a crime. If somebody has a photograph or a video of you involving in a homosexual act with another person, you can be put behind bars. Okay. Anybody, do you know what section it is? Section 497 of IPC, I believe. So that was actually struck down by the judges of Supreme Court recently. Decriminalization of homosexuality had actually happened. So anyway, don't worry about the section and all. There is a particular provision in the Penal Code. 377. That's correct. Section 377 of IPC. So homosexuality, it's a personal choice. Okay, not every human being is the same. People have different needs and different tastes. So a person, if he is homosexual, he is not disturbing anybody. He is just having a good time in his home, in his personal space. Why should the government interfere into his happiness? But this was a law this was a penal provision which was there in our IPC, and this penal code criminalizing homosexuality is a part of your colonial acts. Britishers, they had, do you know what is called as Victorian morals? Do you know what is Victorian morals? Have you heard of that word, Victorian morals? Okay. Basically, it's Britishers' ideas and mindset on what is right and what is wrong. Okay, Indians, we were always very liberal. We were always a very liberal society. Our approach towards life has always been one of indulgence. Okay, Indians are just like Greeks. We enjoy a lot. There is nothing which can restrain us. Our philosophical systems have all placed so much of emphasis on living life to the maximum, right? So, and if you go and look at Khajuraho statues, if you look at Kama Sutra, you get an idea that Indians were great experimenters. Okay, we just try anything and everything out. So we were so liberal in our approach, whereas British society, English society, they are a crazy society. They would always want to be judgmental about others. They would want to be categorizing certain things as not correct for the society, not healthy for the society. So it's not a very liberal society. In fact, we are the most liberal society. It is just years and years of colonial rule which have brought in so much of conservatism in our approach. Okay. So anyway, a reflection of that conservatism is what we retained as those colonial acts. Indian Penal Code is a colonial act which criminalized homosexuality. So we retained it. We retained it until recently it was actually decriminalized by Supreme Court. There was a case involving homosexuals which was brought to Supreme Court, and Supreme Court said IPC 377 itself is unconstitutional. It is wrong. Okay. So let's say there are some 3 judges. There is a judge of Supreme Court who is called as Chandrachud. Okay. Justice D.Y. Chandrachud. He's Chandrachud Jr. Earlier there was another Chandrachud. In 1980, he was the judge who gave this famous verdict called as Minerva Mills verdict. We will discuss it tomorrow when we discuss about basic structure doctrine. So his son is this present Chandrachud. So he is presently the judge of Supreme Court. Okay, Supreme Court is another feudal institution. It's not as noble as we people might think it to be. It's a very feudal organization. It's only the sons and daughters, not even daughters. It's such a parochial, such a misogynist institution. Okay, how many women's judges do we actually have in the bench of Supreme Court? I think only one I know, Indu Malhotra is there. I don't know if there is any other judge, if there is any other women judge in Supreme Court. Out of 34 judges, I think maybe 1 or 2 judges might be there. I'm not very sure. Ideally speaking, women are 50% of the population. So they should have been 50% of the judges, right? But it's a men-dominated institution. Next is, it is a high caste dominated institution. You will not have one judge of scheduled caste, not even one SC judge is there in Supreme Court as a judge of Supreme Court. Okay. Maybe very, very few OBCs, not even sure if there are any OBCs only in the first place. But this is how the Supreme Court as an institution actually behaves. No wonder there was so much of demand for reformation first to happen in Supreme Court only. People were demanding that Supreme Court is not capable of self-regulating itself. It is only, this collegium system is only bringing sons and nephews and nieces of, not even nieces, only nephews, sons and nephews of the earlier judges, only they were handpicked, only those people are coming and becoming again and again as the judges of Supreme Court. So something is wrong with this collegium. That is why the government tried to introduce an alternative system in the form of National Judicial Appointments Commission. NJAC, it's a body which will have 50% composition. NJAC is a body which will have 50% composition of judges of Supreme Court. Another 50% will be from Parliament, Executive, all members will be there. So that now we are bringing in some transparency in appointments of judges. Otherwise, what goes inside collegium, what discussions goes on, everything is a secret. Okay, it's not released to the public, or what discussions happen in the collegium is not even brought to the notice of president. Only a recommendation is given. These are the grounds why we recommend this person. So that is why government tried to bring in some transparency. It want to make judiciary really reachable for many other judges also, apart from the same exclusive families who keep on coming to Supreme Court. And finally, NJAC was once again struck down by Supreme Court as unconstitutional. It is a threat to our independence. It is violating our freedom. Okay, so it was widely criticized. The action of Supreme Court to strike down NJAC was widely criticized by all sections of the society. It was a dark, shameful encounter. It was a dark, shameful act on the part of judiciary. Anyway, the reason why I'm discussing all this is, it was about, why was I discussing all these things? Section 377. Okay, yeah. I'm in the process of discussing about how Constitution ensures the independence of the judges. So we have discussed some 3-4 methods. Another provision given in the Constitution is there should not be a discussion on the character or the conduct of the judge of Supreme Court. You should not discuss about that. Why? Justice Chandrachud, he gives a decision saying that homosexuality is not wrong. Homosexuality is not a criminal act. People are free to indulge in whatever they do. Once he gives this kind of a judgment, and tomorrow in Parliament someone discusses, I think Justice Chandrachud is a homosexual. Such a kind of a person with an immoral outlook towards life in his personal conduct should not be allowed to hold position as a judge of Supreme Court. If somebody makes this kind of a discussion in Parliament, don't you think it will affect the emotional state of judge of Supreme Court? Any judgment that he gives, immediately Parliament will start criticizing the judge's personal association. Okay, judge's personal character will now be questioned in the open floor of the Parliament, so that it goes and reaches everybody that and Indian people are not really so educated or so mature in their thought process. They will just believe whatever is being discussed and talked about. In fact, they will be more open, more happy to comment and criticize. That is their personal hobby, national hobby, right? Just to talk rumors and gossips. So the judge will be mentally affected. In such a mentally affected state, he will not be able to perform his duties fearlessly. That is why you can never discuss the conduct or the character of a judge of a Supreme Court. Okay. Normally, you cannot discuss. It can be discussed, but only on one permissible ground. That is, if a removal motion, as per Judges Enquiry Act, to remove a judge has been admitted. As you know, a motion has 3 phases: admission, discussion, and finally you go to the voting phase, right? So a motion has been admitted. A removal motion of a judge has been admitted in the House. After that, anything can be discussed. Okay. So if a removal motion is admitted, it means that the matter is something serious. Maybe the judge is actually a wrong person. So we have to have an in-depth discussion on his conduct, and we should decide whether we should remove him or we should retain with him. So that is why normally the Constitution prohibits any discussion on the conduct or the character of a judge of Supreme Court. It can be discussed only on the basis of a removal motion that has been introduced in the Parliament. Okay, and the removal motion is governed under this Judges Enquiry Act. My question is, can a removal motion of a judge of Supreme Court, can it be introduced in Rajya Sabha, or should it be introduced only in Lok Sabha? What would be your answer? Yeah, the response is correct. It can be in either of the houses. Correct. So it can be introduced in either of the houses. To introduce in Lok Sabha, to even admit the motion has to have the support of 100 members in Lok Sabha. That is, if Rahul Gandhi wants to remove a judge of Supreme Court, and for that a discussion has to take place, Rahul Gandhi gives a notice of removal motion to the Speaker and he says, this is the removal motion. Speaker will immediately ask, do 100 members in Lok Sabha support it? So don't you think it's a tough process to even introduce it? Yes or no? Because the minimum quorum that is required in Lok Sabha is only 55. And having 100 members on a single day is not such a simple thing. Even if there are 200 members on a single day, getting 50% of the support so as to even admit a motion itself is quite a tough thing. Okay, so you're making it a serious process. It should not be an easy process. So having 100 member support to even introduce a motion gives some kind of seriousness to the charges that is made against the judges. Just because a judge has given a particular kind of a verdict alone doesn't mean that a removal motion can be introduced. The members of Parliament will think twice before expressing their support for such a kind of a removal motion. Whereas if a judge of Supreme Court has been caught in a sex scandal, okay, a videotape has come out of this particular judge. In that case, of course, maybe 100 members, why only 100 members? Even 100, all members might even give their support. So you're giving some seriousness to this process. Otherwise, any MP, if he has some local grievance, he will introduce a removal motion and it will be an unnecessary waste of time of the House. That is why, to impart some element of seriousness, the support of 100 members in Lok Sabha has been made as a mandatory condition. It's only when you have at least a support of 100 members, a removal motion can even be admitted in Lok Sabha. Whereas in Rajya Sabha, to get a removal motion admitted, you have to have the support of at least 50 members of Rajya Sabha. Okay, half the size, so half the number, 50 members if they support, a removal motion can be admitted. So let's see what happens. Let's say in Lok Sabha, 100 members have expressed their support. So now the motion is admitted. So once it is admitted, next it will be discussed and it will be adopted. For adoption, you require a special majority. So let's say the first house has admitted, discussed, and it has adopted. It goes to a second house, Rajya Sabha, removal motion. Again, you need the support of 50 members here. Admitted. As soon as it is admitted, before discussion, an enquiry committee will be constituted. Okay, an enquiry committee will be constituted. And who are going to be the members of this enquiry committee? The Judges Enquiry Act ensures judicial independence here also. Let's say this enquiry committee will have only parliamentarians as members. If that is the case, can you expect the enquiry process to be an independent process? You cannot. There may be an independent inquiry, but at the same time, there is also a chance of a bias which can creep in, correct? That is why Judges Enquiry Act, it ensures that the members of enquiry committee, they are members of judiciary itself. So who are these three? It's a 3-member enquiry committee. Who are they? One is a judge of Supreme Court. The other one is a chief justice of any other high court. Third is a eminent jurist, someone who is really good with law. Okay. So it's this 3-member enquiry committee will be constituted. And this enquiry committee will issue summons to the judge who is now being considered for his removal. This 3-member committee will give a summon, so the judge can appear before the 3-member committee, and the judge will make his arguments. He will say why he should not be removed. He will make his defense. Even after that, the enquiry committee finds him, no, you are guilty. You should not continue as a judge of a Supreme Court. If the enquiry committee still has that kind of an opinion, then this will be, the report of the enquiry committee will be tabled for discussion, and then voting will happen. Voting once again by special majority. Okay. It is through this process, removal motion for removal of a judge of Supreme Court is successfully adopted in first house, in second house, and after that, the president will issue order of dismissal. Then the president will remove a judge of Supreme Court from his office. So this is the process that needs to be followed for the purpose of removal of a judge of a Supreme Court. So this is a very, very tough process. Till date, not a single judge of Supreme Court has ever been impeached. The closest a judge of Supreme Court ever came to being impeached was in 3 different instances, 2 or 3 different instances. The first one was during 90s, when there was one judge. His name was Justice Ramasamy. Okay, Justice Ramasamy was a judge of Supreme Court. So there was a removal motion against him. It was introduced in Lok Sabha, and in the first house itself, the motion actually failed. It was adopted. The removal motion was adopted, but it did not pass through. It failed because Congress party, which was the ruling party at that time, Congress party just abstained completely from voting on that particular day. So Judge Ramasamy his removal motion was not even successfully adopted. Even in the first house, it was not adopted. Okay. And the closest another judge had ever come to being removed was Justice Soumitra Sen. You don't have to note down all these things. These are useless from exam point of view. They will not be asking all these in prelims, but maybe if there is a question in mains, something about judicial independence or something about alternate method selection of judges, if you have any questions here, maybe you can bring this point out in your answer, and you can say that the present system of removal of judges is very difficult. It gives too much of protection even to corrupt judges, as in the case, as it has been made evident by the non-removal of impossibility of removal of tainted judges such as Ramasamy and Saumitra Sen. Maybe you can bring this as a point when you talk about the present judicial processes. Okay, but directly they will not be asking you or questioning you about all these things in the examination. So yes, what about Justice Saumitra Sen? Saumitra Sen was the judge of West Bengal High Court, and he was involved in corruption, misappropriation cases. So a removal motion was first introduced against Justice Saumitra Sen in Rajya Sabha. Rajya Sabha successfully passed it. Okay, Rajya Sabha successfully adopted the removal motion. Next, it was about to be introduced in Lok Sabha. Then Justice Saumitra Sen understood, if things go on, I would become the first judge in history of independent India to be removed by this process. So what did he do? Even before the process can take place in Lok Sabha, he himself gave his resignation, and he resigned from his office of judge of Calcutta High Court. Okay, so till today, not a single judge has been removed by this process. And when a removal motion against a judge is given, okay, a notice for a removal motion against a judge of a Supreme Court is given in Rajya Sabha. Let's say it's first introduced in Rajya Sabha. So Rajya Sabha member is introducing, he is giving a notice of removal motion. Is the chairman bound to admit it? Let's say 50 members are giving their support. In that case, is the chairperson of Rajya Sabha or a speaker of Lok Sabha, are they bound to admit the removal motion? Is it mandatory or something? The answer is right. They are not bound to admit it. It is their discretion. So 3 years back, there was a judge called as Justice Deepak Mishra, Chief Justice of India, Deepak Mishra. Okay. So that was the first time in the history of Supreme Court, during the Chief Justice period of Justice Deepak Mishra, the judges of Supreme Court came out of the court and they gave a press briefing. They came and in the open they gave a press briefing. What was the press briefing? They said that Justice Deepak Mishra is discriminating. Very sensitive cases, he is always allotting to only a few judges. He is giving all insignificant cases to us. So they came out like this and they said that Justice Deepak Mishra should be removed. He is not a good judge. Okay, all that statements they came out and gave in the open. So immediately Congress party, they introduced a removal motion in Rajya Sabha. But then the chairman of Rajya Sabha was Venkaiah Naidu. So he just refused to even admit the motion. It had the support of 50 members, but he threw it away. He said, these are not the grounds for removing a judge of, admitting a motion for removal of a judge of Supreme Court. I cannot entertain this. So it is the complete discretion of the presiding officer whether to admit a removal motion or not to admit a removal motion. Okay. So this is another important safeguard. A very, very difficult removal process has been prescribed in the Constitution for protecting the judges from unnecessarily being disturbed and questioned by the Parliament. Okay. These are all some of the safeguards that the Constitution assures so as to ensure the independence of the judiciary. Fine. So we have discussed about the process of appointment of judges. We have discussed about the process of removal of the judges of Supreme Court. So what about discussion of retired judges? After retirement, you can criticize, you can discuss anything. There is nothing wrong about discussion of conduct or the character of a retired judge. You can do anything. He is just a common man after that. After that, there is nothing, no discussions that is going to affect him in performance of his duties. Okay, he is not going to act as a judge anymore. So in no way is a personal criticism on his character going to affect him mentally when it comes to his performance. So there is no relationship, there is no problem. Appointment and removal of judges is related to both Supreme Court and High Court. Removal process is the same. Judges of Supreme Court, High Court, removal process is the same. Appointment also, it is almost same. Anyway, they are also appointed by the President of India only, judges of Supreme High Courts also. Just that there is a small change in the collegium system. Other than that, appointment is the same. There is no, they are also appointed by the President of India. Okay. Sir, does inquiry committee is constituted only in Rajya Sabha? No, it is constituted in the second house. Wherever the motion is introduced for the second house, there you will have to consider an inquiry committee. Is it fine? Can we proceed further? Or do you have any other doubts? All right. So we'll proceed then. We will discuss about the different jurisdictions of Supreme Court. The first one is about what is called as the federal jurisdiction. Do you know which, among High Courts and Supreme Court, which courts do you think had been established first? Was it Supreme Court which came into existence in India first, or was it the High Courts? Or where are the High Courts? That's right, High Courts. Supreme Court, when did it come into existence? That's correct. It's based on the 1935 Act. So earlier, even before Supreme Court came into existence, you have High Court in Madras, Bombay, Calcutta, then United Provinces, Central Provinces. Slowly, okay. Started from here, then went on here, then finally here. So you had various other High Courts. So in India, before independence, High Courts were the highest court of appeal. Okay, High Courts were the highest court of appeal. After that, there is no other court. If High Court has given death sentence, that's all. You have no other option. The only option that you have is going to Britain, and you have Privy Council in Britain. Okay, your only option left out is going to Privy Council in Britain. And in Privy Council, you have parliamentarians. You have members of House of Lords who will be sitting here. They will have one more round of appeal before the Privy Council. All right. So when Supreme Court was created, do you know what was the objective of Supreme Court? Was the Supreme Court created to become the highest court of appeal? Was that the purpose of creating Supreme Court? In fact, it was not even called as a Supreme Court. It was called as a federal court. Okay, a federal court was created as per the Government of India Act 1935. As the name indicates, the jurisdiction of the federal court was not to sit as a court of appeal on High Court's decisions. It was brought in as a court to adjudicate federal disputes, because it was Government of India Act 1935 which actually brought in federalism in India. Okay, 3 different lists. The lists where the states have their own existence, emergency provisions. So you have a lot of federal provisions which are brought in as a result of Government of India Act 1935. And Government of India Act 1935 was enacted by the British Parliament. So parliamentarians were clearly aware that when we implement this act, definitely there will be problems between the central government and the provincial governments. So if there is a conflict between the center and the provinces, how should we take care of that? That is why this Federal Court of Justice was created as per Government of India Act 1935. What do I mean by federal disputes? Federal Court of Justice to deal with federal matters. Whenever there is a problem between the different units in a federal political setup, what are the different units in a federal political setup? You have the center and you have the provinces, right? So you have center versus provinces, or you have province versus province. Such kind of any kind of a disputes will all be categorized as a federal dispute. All these kind of disputes will be heard only in Supreme Court. No other court in India will have jurisdiction powers to hear disputes that are federal in nature, disputes that arise because of a conflict between one unit of the federation and the other unit of the federation. Okay, so this is the exclusive jurisdiction of Supreme Court. So you can say that federal jurisdiction of the Supreme Court is exclusive in nature, because no other court can hear into these federal disputes. In your Lakshmikant, you will also come across a different word: original and exclusive jurisdiction of Supreme Court. What is the meaning of this original? Original, where it starts, that is what is called as origin, right? So such federal disputes can be only litigated in Supreme Court. It means that it can only origin from Supreme Court. That is what is called as original jurisdiction. The case will directly origin at the level of Supreme Court. Whereas you look at a murder case, do you know a murder trial? Someone murders another person. Do you know where the case will start? Do you have any idea? Okay. So I believe you can hear me. My battery is dead, Mike. So you'll have to wait for some time. battery முடிஞ்சிச்சு பாருங்க, நான் மாத்திட்டேன், சார்ஜ் போட்டுருவேன். So your answer is right. The answer is it starts from Sessions Court. Basically, the hierarchy of court is at the top you have Supreme Court, then you have High Courts, and then you have the lower courts at district level. This is at the state capital level. This is at Delhi, one court for India, and at district levels you will have different courts. At the district level, the courts, they deal with two prominent matters. Okay, one is what is called as the civil matters, the other one is what are called as criminal matters. So what is this civil and criminal matters? Any idea? What is meant by civil matter and what is meant by criminal matter? Civil disputes are, I think I have already told you this during president discussion. When we had discussed about president, have I already given you an idea about what is the difference between civil cases and criminal cases? Okay. Which previous status can be brought? Yeah, criminal matters, of course, okay. Previous status can be brought. That is right, okay. So, Kishore. Kishore, are you a lawyer, Kishore? You're a mechanical engineer. Okay, okay. All right. So, okay, even I'm not a lawyer. So, my way of understanding it is civil disputes are between two individuals. I mean, always disputes are between two parties. You need two parties to have a problem, a dispute. But in criminal cases, one party is necessarily the state. Okay, the government has to be one of the party when it comes to criminal offenses. Okay, so both these are treated in a very different manner. Civil disputes are treated in a civil procedure code. There's a different kind of procedure in dealing with these matters. Different procedures, criminal procedure code when it comes to dealing with criminal matters. Okay, so both these different types of disputes can be adjudicated, can be initiated at the district level. For that purpose, you have a hierarchy of courts which separately deal with civil matter, which separately deal with criminal matters. So what is that hierarchy? At the district level, the court is called as district and sessions court. The district judge, his actual title is district and sessions judge. Whenever he presides over civil cases, he is called as a district judge sitting in the district court. Whenever he presides over criminal cases, he is called as a sessions judge holding his court in a sessions court. So the line converges at district judge. It separates civil matters and criminal matters. Civil matter, you will have a principal senior judge. You will have a junior civil judge. You have some hierarchies. Even district criminal matters, you will have chief judicial magistrate. You will have a subdivisional judicial magistrate. You don't have to be concerned about any of these hierarchies. You just need to know at the district level, in the district court, both civil as well as criminal matters can be litigated. Okay. So, can I say for a criminal case, for a criminal offense, a sessions court has original jurisdiction? If I say that, will it be a correct statement or no? Sessions courts have original jurisdiction with respect to criminal matters. True. So what is the jurisdiction of High Court on criminal matters? When it comes to criminal matters, a murder trial or a rape trial, nobody can directly go and approach a High Court. It is not possible. Okay, you have to. I would say the Sessions Court has a original exclusive jurisdiction. Okay, not exclusive jurisdiction, because even lower courts, Sessions Court is at the top level, at the district level. Then you have the Court of Subdivisional Judicial Magistrate. You have the Court of Chief Judicial Magistrate. So there are different courts at the district level. So criminal cases will start in all different levels. So I cannot say exclusive jurisdiction. Original jurisdiction of Sessions Court applies to various criminal cases. You cannot directly go and file a case in High Court. It's only when you are not satisfied with the judgment of Sessions Court, you can challenge this judgment in a High Court. This process of challenging the judgment of a lower court in a higher court is what is called as appeal. Okay, so I can say that High Courts have appellate jurisdiction over criminal matters. Okay. If you are still not satisfied with the judgment of the High Court, you can go and challenge it on appeal to Supreme Court. So Supreme Court also has appellate jurisdiction on criminal matters. Okay. So this is what is called as original jurisdiction, appellate jurisdiction. Whereas when it comes to federal matters, the jurisdiction lies only at the Supreme Court level. So original point itself is Supreme Court. The issue will be dealt only in Supreme Court. That is why in Lakshmikant you'll come across this word. Original and exclusive jurisdiction of Supreme Court extends to federal disputes that are federal in nature. Okay. So does corruption case come under civil or criminal cases? Corruption case is a criminal offense. So this is with respect to federal disputes. We have some other jurisdiction also. We will stop here. If you have any doubts, you can ask me. Otherwise, we'll stop here. We will continue the rest in the next class. Okay? Is it okay if we continue the rest in the next class? Or should we continue here now also? Water dispute between two states are not dealt with under this jurisdiction, right? No, it's not dealt with it. Because water disputes cannot be, it is excluded from the jurisdiction of normal court of law. Okay, because Article 262 says so. We will discuss it later, because now if I were to bring it in, there will be a lot of confusion. But you can also talk about water disputes through a different process. That's the process called as special leave to appeal. Please wait. We will proceed in a phased manner. Okay. So I'll discuss with you about that tomorrow. Tomorrow we'll have a discussion on why this Kaveri water dispute had gone to the level of Supreme Court. Okay. So we'll discuss that tomorrow. Why corruption is a criminal offense? Just because corruption is a crime. That's why. Because the state is going to prosecute you. Just like how using obscene language in the public, using bad words in the public, in the same manner how it can be a crime, in the same way, corruption is also crime against the larger country itself. It's not against one particular individual. It's against the entire nation. You have swindled the public money. So it's a crime against the entire country. So the state will be the other party. It is not me versus Tahsildar, Santosh versus Tahsildar. No. Tahsildar versus the government of Tamil Nadu. If the Tahsildar is caught red-handed taking a bribe. Okay. So I'm very tired. So we will finish it. We'll conclude it here. We'll continue the rest of the discussion tomorrow. All right. Thank you. And if you have any doubts, you are free to ask, or otherwise we can wind up the discussion. Okay, then see you tomorrow then. It's very easy. Go read through your Lakshmikant. Very, very simple topic. Polity, easy to read, easy to forget. So just keep revisiting your books again and again. Okay. So that's all. Thank you. We'll discuss tomorrow.